Good evening, folks. This is Dan Bouchard with Remax Realty Group, the managing broker of our DC office. And I want to welcome you to today's discussion. And we are talking about the relationships of agents, companies, real estate companies with the consumer. And we're talking about that in respect to Virginia law. So I'm going to go ahead and share my screen with you. And just keep in mind, please, that this discussion is a discussion that is related to my experience in 26 years of selling real estate and is not meant to be interpreted as legal advice in any way, shape, or form. Please contact an attorney if you're trying to understand. If you need legal assistance, please do contact an attorney or an accountant for financial assistance. A lot of the real estate world overlaps into other professions, but we are only focusing on our real estate duties as real estate agents and real estate brokers. So one of the things that we have in terms of establishing those relationships is understanding that there are different kinds of relationships in real estate. And the whole concept of engaging with a real estate agent is a lot different than it would be if you would go to a department store and talk to a salesperson, or if you would talk to the mechanic or the car dealership or other things like that. And a lot of times consumers, it's very easy to think of real estate in terms of those kinds of consumer related industries. But in fact, the law is very, very different when it comes to those kinds of interactions. And it's very different because it is strictly defined in law. So with today's discussion, we're talking about real estate law. And this particular website is one of a few different websites that publishes Virginia law. And they do a pretty good job of keeping up with the terms of it, with the accuracy of the law. So they do a really good job of keeping that up to date. And you can see that this is updated, including 2022 updates. There are many others out there that will provide you with the same information. So what I'm going to do right now is we're going to jump in and discuss some of the kinds of relationships that you might have with real estate agents. It's very, very different when you're talking to real estate agents. So agency means every relationship in which a real estate licensee acts for or represents a person in an agent as an agent by such person's express authority in a commercial or residential real estate transaction, unless a different real estate relationship is intended and is agreed to as part of the brokerage agreement. So agency refers to a contractual relationship, and that's basically what that means in a nutshell. We're going to go ahead and dive into this a little bit deeper. And when we're talking about an agent, we're talking about agent means a real estate licensee who's acting as a standard agent, which means the full layer of full service duties in a real estate environment, or a limited service agent who is only doing limited services for limited fees and limited exposure and liability. So obviously limited service agents do things for a lot less money because they're offering a lot less service and they're not accepting liabilities that might otherwise be brought onto them by being a standard agent. That's kind of where that standard agent phrase comes in. And then similarly, an agent in a commercial real estate transaction has similar kinds of arrangements. So when we're talking about engaging with a real estate company, we're talking about a brokerage agreement, and a brokerage agreement can be called, is sometimes called a listing agreement. Sometimes there are buyer agency agreements, tenant agency agreements, or landlord agency agreement. So each of those scenarios, depending on where we fit into the picture, obviously is pretty self-explanatory, but each of those scenarios is defined by a written document that is signed by the brokerage and signed by the consumer and forms a binding document of responsibilities, duties, and loyalties, etc. So it means it's a written agreement creating a brokerage relationship between a client and a licensee. The brokerage agreement shall state whether the real estate licensee will represent the client as an agent or as an independent contractor. And in most cases, we're going to be representing you as an agent for this discussion. And so that'll be where that goes. So the brokerage relationship does mean the contractual relationship between a client and a real estate licensee who has been engaged by the client for the purposes of procuring a buyer, a seller, an option, a tenant, a landlord, a ready, able, and willing to sell buyer, to buy, sell, option, exchange, or rent real estate on behalf of a client. So if I'm a buyer's agent and I've signed a buyer agency agreement with you, then we're looking for a property for you to buy. And it's my job to not only find the property for you, but also to engage in that transaction so that we balance the needs of protecting your interests in as much as we can, while at the same time achieving our goal of finding and achieving a successfully ratified contract to get you to the settlement table so you can then own your new home. Similarly, it's the same kind of a situation. If I am representing you as a seller, then the relationship is defined in writing, and we are looking to find that one special buyer and engage in a negotiation with that buyer in order to get the best possible deal for you within the parameters of also protecting your liabilities and your financial interests as well, and keeping the confidentialities separate as that needs to be. And we're going to talk about that here in a moment. So the key phrase that we like to focus on here in this industry is ready, willing, and able. Any buyer who's ready, willing, and able to buy a property, any seller who's ready, willing, and able to sell a property, those are the kinds of relationships that we want to engage in. Sometimes we have sellers who are ready and able, but not willing to sell the property for what it needs to be sold for. Other times we have properties who are willing to sell the property and able to, but they're not quite ready yet and they need more time. Other times a buyer might be ready and willing, but they don't have the ability because maybe they don't have the financing. Those are just examples of how that phrase kind of plays out sometimes. So now let's talk about client and what it means to be a client. So in our vernacular, we often discuss the term client and customer, and we use those pretty interchangeably in our society. But to a great extent, particularly in real estate, the word client has a specific meaning, and it's defined here in Virginia law. And it means a client means a person who has entered into a brokerage relationship with a licensee. So if I have entered into a buyer agency agreement with you, then I have obligations to you, I have loyalties to you, I have fiduciary responsibilities to you. If I'm a seller's agent, a listing agent, same thing. I have loyalties, I have duties, I have obligations to perform things, and I have fiduciary obligations to you. And I can't reveal privileged conversations that I have with you to the other side. Same thing goes across the board. Commercial real estate, we're not going to talk about that right now, although the concepts still apply to commercial real estate as well. The term common source information company is one that really does not apply to real estate companies particularly, but what it does apply to is commonly, this is referred to the local board MLSs, the multiple listing service that we use, that real estate agents and companies use in order to promote the properties that they have to sell. That's not the relationship that we're talking about today, but that is something that is common, that is defined here in Virginia law. So the difference between a client, which we talked about in a few minutes, a couple of minutes ago, and the customer is that the customer has a far lower level of service that they're given in terms of their interactions with a real estate agent. And so when we are talking about a customer, the real estate agent owes the customer honesty, and that's about it. There are some subcategories of what we owe underneath the concept of honesty, but for the most part, it all is boiled down into performing honestly for the customer. So, for example, if you are a buyer and you Google real estate agent in my neighborhood and you come up with an agent's name and you call that agent and say, hey, I want to go see 123 Main Street. Well, that's not really the best way to utilize the services of a real estate agent, but you could do it. And in that kind of a situation, because you do not yet have a relationship with that agent, you are a customer of that agent. And they have the duty to be honest with you, but they do not have the duty to be particularly to give you guidance, advice, counsel, recommendations, and looking out for your interests. In addition, they do not have any kind of fiduciary loyalties to you. So it is never really, in my opinion, it is never really a wise decision for a consumer to simply say, hey, show me this property 123 Main Street, because that agent is not there to protect that person's interests. So it is much more advisable, and this is the purpose of agency law, is so that the relationship there can become a client relationship where there is a fiduciary liability of that agent to represent and care for that consumer, to represent their interests. Okay, so within the concept, we've talked about buyer agents and we've talked about listing agents. And so within a real estate brokerage, a brokerage is headed by a principal broker. In most cases, it's a principal broker who owns the company or who is in charge of the company in that jurisdiction in the state of Virginia. And then oftentimes they have associate brokers who manage the various offices of their companies. And I happen to be one of those associate brokers who manages an office. And so what we have here is a scenario where we have agents operating underneath us who are serving their respective customers and clients. And we are engaging in the business of buying and selling and renting and leasing real estate. But what may happen is if Joe Schmo on this side has a listing and Sally Smith on this side has a buyer, and both of them are affiliated with my brokerage, then Joe and Sally are both designated agents. So that's what this phrase right here is, this designated agent or designated representative. They are designated agents because they work for the same brokerage, the brokerage with which I am. And underneath that umbrella, the brokerage itself is a dual agency service provider because they had equal fiduciary loyalties to the buyer and the seller. And that's not usually a problem at all. Because we don't generally, we have a separation of the loyalties because one agent is representing the seller, one agent is representing the buyer. And so there's a separation and a designation of those two walls. And so we don't reveal privileged information across to the other. At least we're not supposed to. And that's and my experience is that is usually mostly honored throughout the industry. But you know, humans are humans, so there are some occasional failures in that. So a designated agents have loyalties specific to their own individual clients, either the buyer or the seller. So that's a designated agent. A dual agent is if I have a property that I am listing for sale And I also have a buyer that I introduced to the property. And both of these clients are my client relationships, and I have written agreements to establish those relationships with me. Then I become, in that situation, when I've introduced them to each other, and we are beginning the process of going through a transaction and potentially joining those two together in a transaction, I become in dual agency if they have agreed to, and if I have disclosed that to them and they have agreed to be in that situation. Now, dual agency require, because it's impossible to be absolutely 100% fiduciarily bound to represent both parties simultaneously. In order to do that, you would have to reveal privileged information of one to the other, and then back and forth. And so that becomes too complicated. So the way that the law has it structured is that there is a reduced level of service in dual agency, meaning that one party cannot reveal, so that the agent cannot reveal privileged information of one side to the other, and that you are there to facilitate the process. And usually what ends up happening in most brokerages is there will be a broker that steps in to the transaction and negotiates with one side or the other side to coach and guide them to make sure that their interests are protected beyond what would otherwise be a sticky kind of a situation. Personally, for my own practice, I do not participate in dual agency because I feel it is a disservice. And in fact, in some states, it is illegal. Some states define dual agency a little bit different. For example, Maryland defines it a lot different than Virginia does. We're not going to talk about Maryland law right now, but I just want you to know that dual agency is one agent with two clients in the same transaction. Designated agent are two agents with one property and two different clients. So that's the difference between designated and dual agents. So, and if you have questions at any point, feel free to send me an email, adb@goodvibehomes.com, and we'll be happy to talk about this some more. But let's continue on. So an independent contractor means a real estate licensee who enters into a brokerage relationship based upon a brokerage agreement that specifically states that the real estate licensee is acting as an independent contractor, not as an agent, and shall have the obligations agreed to by the parties in the brokerage agreement, and shall comply with the provisions of subdivisions A3 through 7, subsections B and E of 54.1 -2131, et cetera, So that is the definition of an independent contractor. Licensee is fairly descriptive, fairly obvious what that is. The state has issued a license to an individual salesperson or a broker who has met some educational and performance criteria in order to have that license. And they have to maintain the state standards of education and continuing education and compliance to the law and the ethics required. Now, when we're talking about the traditional listing agreement and the traditional buyer agency agreement, those are called standard agency services because they're full in their capacity, and the service that is rendered to the client is a full service transaction. However, there are some circumstances when consumers believe that they are better served by paying a lower fee and getting just a very specific limited service, and that the liability that the agent involved in that is very limited and in such a transaction, and the services that they provide are very, very limited, and they're specifically identified in the agreement that they sign. And for that exchange of limited service, there is a limited fee. But you may wonder if that truly is getting the full benefit of having a real estate licensee working for you when the level of services that they're providing are so minimal. So those are some limitations there. In our brokerage, in my office, we do not participate in limited service, only because we don't feel that it doesn't serve the client, and it does not protect their interests, and it really doesn't mitigate the liabilities very effectively for anybody. So if I have a buyer client, for example, and let's talk about, we're talking about ministerial acts. So if I have a buyer client and and I have fiduciary loyalties to my buyer, there is the possibility that I could do something in terms of helping out a seller or helping out the listing agent in a transaction, and do so in a way that would not be in violation of my ethical and legal obligations to my buyer. For example, if a seller needs to have documents delivered to the buyer, and I don't know, maybe the seller is handicapped and can't get out of the house, and I could get in my car, drive to the seller's house, pick up the documents for my seller and deliver them to my buyer. In theory, I could do that. That would be called a ministerial act, and I would not be violating my fiduciary loyalties in doing that. I wouldn't be engaging in chit chat with the seller. I wouldn't be engaging in exchanging, private privileged conversations. I'd be very, very limited in the scope of what I would do. Only do the approved act that was discussed with the listing agent or the buyer's agent, whichever the case may be, and we get on with our day. So a ministerial act is not necessarily a violation of our legal and ethical obligations to those clients. Property management agreement is one that is strictly about managing a piece of rental property or commercial real estate or a homeowner association that will manage the expenses, the finances, and manage the accounting on behalf of an owner. And that is done by a specific licensee in Virginia, and it is based on a written agreement between the property manager and the owner of the real estate, which will describe in detail what the property management firm will do and what they will not do. So that is one thing that we have available to us. Residential real estate is anything that was, the traditional definition of real estate, back 100 or so years ago, was the earth below you, the sky above you, and anything that was built on the land that you are buying. So a house that was built on the land, and everything, all of that was the traditional means of real estate. Well, somewhere around the Great Depression, it was realized that a lot of people couldn't afford to buy the sky above them, the land below them, and the house on the lot. So what they ended up doing is a lot of people came up with a concept of inventing the concept of a condominium, where you actually own the real estate, the actual interior of the building that you are in. You actually own that, and you are deeded that. You can get a mortgage on that, and you own a share, and you own an obligation of the maintenance of the share of the association that takes care of the entire property. That would be, in essence, what a condominium is. Another type of real estate that was created around the same time was called the cooperative. And cooperatives, in essence, are not actually real estate per se. They are more akin to stocks and bonds. And by virtue of your ownership of these stocks, let's say, you are permanently assigned a living space in an association, and you are given that living, and you have the same obligations of maintenance, and there's a board that manages it, just similar to what a condominium is, but it's just a different type of an arrangement. And so you can't typically get traditional mortgages for co-ops, but you can get financing. That gets a little bit into the weeds. I don't want to get too far into that, but let's just understand that you can get financing, but it is a little bit different than the traditional mortgage market. And so we did talk about a minute ago, we said that there are standard agents, and that is the full service of agency relationships that are given into buyer agent, listing agent, that are not in a limited service agency. So that's kind of where that is. So I do want to go ahead and bring us to another screen. And we're going to go ahead and describe in a little bit more detail some of the forms that we use frequently in our real estate. And there are different variations of these forms. This particular one is produced by the Virginia Association of Realtors, and it discusses the disclosure of brokerage relationship explanation to consumers. And I really love this form because it really lays it out and explains in simple terms what the nature of the relationship is. And I think it's everybody's obligation in Virginia, all of the licensees' obligation in Virginia, to use this with every single person they come in contact with, because it really explains the relationships very, very well. So when we're talking about the seller, so to whom the licensee represent, when we're talking about the seller, a licensee represents a seller via a written brokerage agreement called a listing agreement, in which case the licensee owes his primary responsibilities to the seller. The licensee must disclose his relationship with the seller whenever dealing with an unrepresented buyer. And the licensee is also allowed to assist an unrepresented buyer with ministerial duties, such as filling in the blanks of a contract and holding the escrow deposit. So if I am a listing agent, I can write a contract that is, I can write a contract in the interest of protecting my seller's interest, even though I'm sitting here with a buyer, and my buyer can tell me, okay, I want you to put in this blank line, and I want you to put in this blank line. And they will tell me, I'm not allowed to advise them and guide them and coach them into how to protect their interests, because that's not my relationship. That would have been a dual agency situation, but I'm not in a dual agency situation in that case, because this buyer is my customer. So that's why we're talking about this in these terms. The licensee is also allowed to assist an unrepresented buyer with ministerial duties. The acts that I'm doing by filling in the blanks for the buyer are a ministerial duty, and that buyer is a customer. The seller is my client. Similarly, if we're talking about a relationship with the buyer here, if a buyer desires to be represented by a licensee, then the buyer and the licensee must enter into a written brokerage agreement by which the licensee agrees to represent the interests of the buyer. And the licensee must disclose this relationship with the buyer whenever dealing with an unrepresented seller. So I have to tell my buyer that we are dealing with an unrepresented seller, and that my loyalties are to my buyer, and that the seller is not represented. So I could, in theory, be in a buyer agency agreement and encounter a for sale by owner seller and write a contract in the interest of protecting my buyer's rights and their my fiduciary responsibilities to the buyer, and totally eliminate what the seller's rights and protections need to be. And I would be completely in the right in doing so, because in this case, the seller is a customer. So furthermore, the licensee may perform ministerial duties for an unrepresented seller, such as delivering offers and counteroffers. So that would be an example of ministerial duties as well. So, buyer and the seller, a licensee and his firm may represent both the buyer and the seller in a particular transaction, but only with the informed written consent of both the buyer and the seller. So remember, I mentioned that earlier. So a licensee representing both the buyer and the seller in a dual capacity is necessarily limited in his ability to represent either the buyer or the seller fully and exclusively. The licensee must safeguard the confidentiality of any information obtained within the confidentiality. So if the buyer says, If I'm representing both the buyer and the seller in a transaction, and the buyer tells me I'm willing to pay $1 million for this house, and the list price is $500,000, if the buyer has told that to me in confidence, I am not allowed to convey that to the seller. Okay. And that can get tricky because, you know, I do have loyalties to the seller, right? And the goal is, and if I had not been in a dual agency situation, I would be obligated to tell the seller that information. But because we're in a dual agency situation, I can no longer be completely candid and forthright with all of that privileged information that's discussed. So I can't reveal privileged information of one party to the other party. So it's important to understand that when you're in dual agency, that's what happens. You're getting a lower degree of service. And if you're not getting a lower degree of service, you may actually be getting disserviced. So this kind of a scenario comes up when, you know, you're seeing an advertisement for 123 Main Street, and you call up the listing agent on 123 Main Street, and that's Sally Smith, and Sally Smith answers the phone, and then she engages you in a buyer agency agreement. She is a dual agent in that kind of a situation. Once you've established your buyer agency agreement, because she's in a binding relationship with the buyer, binding relationship with the seller, and therefore the duties that she owes to both of those parties is lowered. So just be aware of that. Designated agency, remember that's one property, two separate agents, same brokerage. All right, the next form that we have here is a disclosure of designated or a designated agency or representation in a real estate transaction. And then it also, so this is basically the form that we're using to describe and notify the parties that on this particular property, 123 Main Street, that the seller and the buyer, or the landlord and the tenants, it'll be one of these boxes will be checked. The principal broker has assigned Joe Schmo to be the representative for the seller, and Sally Smith, the principal broker, has assigned the principal or supervising broker has assigned Sally Smith to be the broker of the agent, and they are to be the broker of the buyer here, and they are operating as a standard agent with the full services, a limited agent with very restricted services, or as an independent contractor. So those are the same thing. And we have a similar document that is used to describe the dual agency situation as well. So that's the nature of it. Please keep in mind that this is not a legal discussion. This is simply a discussion about my experience and my knowledge of 26 years in the industry and participating in our transactions. And this is to help you as a consumer or help you as an agent better understand what Virginia law says about agency relationships. If you've got any questions, feel free to give me a call at 202-309-2339 or adb@goodvibehomes.com. Thanks so much and have a great day. Take care. Bye.